Good afternoon, panelists and attendees. My name is David Saab, and I represent the Thames Valley Chamber of Commerce, and I'll be your host for this webinar. Today, I am delighted to welcome our panelists, Adam Dowdney and Harriet Jones, partners at IBB Law, a full-service law firm, and Ben Butler, director and owner at Macbeth Insurance, leading independent chartered insurance brokers. Today, we shall attempt to uncover the concept of force majeure and the rule of frustration. We shall look at the implications of these concepts on contracts due to COVID-19 and explore whether changes to standard contracts are needed. And Ben will help steer us through business interruption and other risks, both short and long term. We encourage all attendees to post questions in the Q&A box, and we'll attend to these at the end of the webinar or possibly during, at the discretion of our generous panelists. We'll see how we go. Without further ado, I would like to hand over to Harriet.
Great, many thanks, David. And thank you to all of you for joining us today. As David said, Adam and I are both partners at IBB Law, specialising in corporate and commercial matters. I keep myself out of mischief by advising large corporates and SMEs on a range of commercial matters, from supply arrangements to GDPR to franchising, and I also advise on company structures, reorganisations, acquisitions and disposals. As well as opening our new office in Reading this year, Adam keeps himself busy on a range of corporate matters for our clients, including mergers and acquisitions, MBOs, private equity transactions and restructurings. But that's enough about us. This afternoon, I'm going to give you some thoughts on the impact of COVID-19 on commercial contracts, and specifically whether force majeure and the doctrine of frustration and/or supervening illegality may apply. And then Adam is going to suggest some positive actions that businesses can take now, possibly to make the most of a bad situation whilst we're all in lockdown. So firstly, let's have a look at force majeure. It's a phrase that many people will be familiar with, but until now have perhaps not had to give it too much thought. The phrase alone has no legal definition in England, but it has a statutory meaning in France. Under French statute, a force majeure event justifies suspension or termination of a contract, even if the contract does not contain a provision in that respect. 3 conditions must be met for an event to qualify as a force majeure event in France. The first condition is that the event must have been beyond the control of the debtor, and the prevailing view from early commentaries in France is that COVID-19 and related lockdowns may qualify as events beyond the control of debtors. The second condition is that the event in question was not foreseeable to the parties at the time of the conclusion of the contract, and this is judged on a case-by-case basis. And the third condition is that the event must be irresistible, meaning that the party claiming force majeure must prove the event made it impossible to perform the contract in any manner that was not preventable. Again, this is judged on the specifics of the case and whether it was actually impossible as opposed to just excessively onerous. Therefore, in France, if an event of force majeure is established, the obligation under the contract may be suspended if the impossibility to perform the contract is temporary. But if the impossibility to perform the contract is not temporary, the contract is terminated by operation of law and the parties are discharged from their obligations. It is possible, therefore, that the COVID-19 pandemic may constitute a permanent force majeure event for those contracts where time is of the essence. But I would definitely recommend some advice from a lawyer in France rather than just a mere English lawyer like me, if you have any contract that's governed by French law and jurisdiction. As I said earlier, the term force majeure is derived from French law and has no recognised meaning in English common law. It's therefore important to consider the agreement in question and look at how it has been defined, because the cases in court have found that the proper approach to a force majeure clause is to interpret it by reference to the words the parties have used and not just their general intentions. So let's start by having a look at a force majeure example clause, which should appear on your screen in a second. It's a very short clause probably not that uncommon from the sort of thing that you'd see in standard terms and conditions, and dare I say it, perhaps where there's a particular desire to squeeze the terms into small font and all onto one page. The first point to highlight is whether the clause affects one or both parties, as clearly that will impact on the ability of a party to make use of this clause. In this particular example, the clause applies to any obligations of either of the parties, which is quite broad. In a negotiated contract, you might see some limitations on what the force majeure can apply to, depending on the subject matter of the contract and, of course, the relevant sector. If you note in the example on the screen, the breach or delay must result from events, circumstances, or causes that are beyond that party's reasonable control. So therefore, the burden of proof is on the party seeking to rely on the force majeure clause. That party must prove that non-performance was due to the event. And it's important to note that the Court of Appeal has said that a clause which includes language referring to events beyond the control of the relevant party can only be relied on if that party has taken all reasonable steps to avoid its operation or mitigate its results. So other variations from the clause on the screen include provisions that the relevant triggering event must prevent performance of the contract. So if this is included, the courts have found that the relevant party must demonstrate that performance is legally or physically impossible and not just difficult or unprofitable. Some other force majeure clauses may require the defaulting party to show that it's used its reasonable endeavours to prevent or at least mitigate the effects of the force majeure. In addition, some force majeure clauses in contracts will go further than the example we've set out here on the screen and will set out a list of events that are considered to be force majeure events. Some do specifically list pandemics, but some don't. It really will depend on the drafting. It is also not uncommon to see a force majeure clause refer to the foreseeability of an event. Many of you may have heard over the last few weeks, Bill Gates delivered a talk back in 2015 where he predicted there was going to be a global pandemic. This has raised an interesting argument. Is there a suggestion that COVID-19 could have been foreseen? I personally don't agree. I think it would have been a brave judge who would agree with that sort of line of argument. And in our example here, there's no reference to whether or not the event was foreseeable, and the courts have not found that foreseeability would be implied. But it is worth noting that the more foreseeable an event is, the more it might be considered preventable or avoidable, and therefore within the party's actual control. As I mentioned earlier, in France, the implication of a force majeure event is suspension or termination as a matter of law. In our example clause, there is a period of suspension or hiatus for 2 weeks when no one is at fault for not performing their particular obligations under the contract. At the end of that period, our clause provides that the party not affected has a choice. They can either do nothing or they can terminate the agreement by giving notice. What the unaffected party will do will be, of course, a commercial decision and will always depend on the wider implications for the business. Depending on the rest of the contract in which this force majeure clause appears, it might be that termination is without liability, except in respect of prior breaches, obviously. But if the contract terms included an advance prepayment for goods or services, then if they weren't provided due to the force majeure event, the paying party should be entitled to some repayment. In short, the force majeure clause, such as this one here, should not be read in isolation. The terms of the entire contract need to be considered to establish a party's course of action. So what happens if your agreement doesn't have a force majeure clause? Well, unlike France, it can't be implied into a contract. So one other point to consider is the doctrine of frustration. The doctrine of frustration was established in the case of Taylor and Caldwell way back in 1863, where the defendants had agreed to let a music hall to hold concerts on 4 specific nights. After the contract was made, but before the first night, the hall was destroyed by fire. The court held that the defendants were not liable to pay damages for failure to perform the contract, i.e. hiring out the hall, because the impossibility of that performance due to the hall being destroyed by fire. Since 1863, there has been some extension of the doctrine set out in Taylor and Caldwell, and a modern test for frustration is now generally considered to be that a frustrating event is one which occurs after the contract has been formed, is not due to the default of either party, is so fundamental that it's considered to be striking at the root of the contract and entirely beyond what was contemplated by the parties when they entered into the contract, and it renders further performance impossible, illegal, or makes it radically different from that which was contemplated by the parties at the time of the contract. If a frustrating event occurs, the parties are no longer bound to perform their obligations. So as you may imagine, the court decisions on this since 1863 have been very specific to the facts of the case. For that reason, frustration is not likely to be a conclusion that one can come to quickly or only by reviewing the contract, because the contemplations of the parties when they entered into the contract are just as relevant as the written agreement itself. So one further thing to think about, and I'm only going to mention it briefly, as I don't think it will be applicable to many contracts, but one other point to think about is illegality. In an English law governed contract, a contract is discharged if its performance becomes illegal under English law. It's quite a high requirement. It's not that there are matters which hinder performance or make it more inconvenient, but the law prohibits performance. To give you an example, there was one very old case where a ship from France was unable to dock in London due to restrictions on movement from France during an outbreak of a very nasty disease affecting cattle. The contract was not held to be discharged due to illegality because it was possible to unload the goods in London, but it just required additional clearance and a different way of doing things. This is why I think it's unlikely that the UK government's measures to tackle COVID-19 are going to give rise to many contractual obligations being prohibited. Inconvenient, definitely, and difficult, absolutely, but very few people will probably be able to say it's completely prohibited. But foreign law supervening illegality is likely to be relevant to international services or supply contracts. An English law governed contract litigated in England but to be performed elsewhere may be subject to the effect of any overriding coronavirus legislation in the place of performance. In summary, there is no easy answer as to whether COVID-19 will give rise to a right to terminate a contract or suspend obligations under it. Each contract will need to be considered carefully to check if there is a force majeure clause, if there is one, whether it offers any relief for the relevant party, and if there isn't a force majeure clause, are the facts of the commercial arrangement going to give rise to a frustrating event? And can a party argue that their performance of the contract would be illegal because of laws made during the pandemic? If the contract is valuable to you, take legal advice on the contract and use that advice to negotiate with the other party to get an acceptable position for your business. I'm also aware of some guidance that was published just yesterday, and you may have seen this, about what they've called responsible contractual behaviour in the performance and enforcement of contracts impacted by the COVID-19 emergency. Nice snappy title from the government. It's a document where the government, and I quote, strongly encourages responsible and fair performance and enforcement of contracts during this public health emergency. It is not a legal requirement. No legislation has been passed in the last 24 hours that I'm aware of. So it's effectively a plea from the government. And whilst I appreciate the sentiment, I would like to point out that as directors, you will have a statutory duty to act in the best interest of your company. So you do need to bear this in mind, and I recommend you take legal advice if you have any doubts. I hope that's been helpful to you and a helpful summary if you're mulling over a tricky contract at the moment. Do feel free to use the Q&A function at the bottom of the screen if you have any questions, and I'll do my best to answer as many as I can, as will all the other panelists. But in the meantime, I'll hand over to Adam for some thoughts on what you and your business could be doing now to try and create some positives from the lockdown.
Great. Well, many thanks, Harriet. I'm just going to spend a few minutes with some thoughts around how business owners can use their time most effectively during the lockdown period. I'm sure, like me, we're all being asked to do those jobs around the house that we've been putting off until we have time. And really, it's exactly the same for your business. One possible benefit from maybe a fall in trading or slightly a less time-intensive working day may be an opportunity for businesses to address those internal housekeeping tasks that have been previously overlooked and put to the bottom of the never-diminishing in tray. Perhaps the time to do it later is now. So, some ideas of some of the things you could look at. I think one thing, these worrying times have made a lot of people realise they don't have a will, or the will they have is out of date. And if you are one of those people, make sure you fix it. But business owners should be thinking along similar lines and considering whether they have the right documents to govern their relationship between their shareholders, both in good and bad times, by way of articles of association, or in particular, a shareholders agreement. If you do have a shareholders agreement, it's worth looking and checking that it reflects how you and your shareholders want to run your business now, and indeed going forward after lockdown. And if you don't have one, what lessons have you learned that have come out of this period that could be addressed in a shareholders agreement? A shareholders agreement can cover any number of matters. For example, share transfers between shareholders or outside of the shareholder group, disposal options, payment of dividends, good-bad leaver provisions, illness and death, and the day-to-day operation of the business through the management of the board and the establishment of committees, which can be pretty important in the current situation. In particular, again during lockdown, make sure your articles allow for remote board meetings and electronic communication between shareholders. And as people take stock of the wider picture, do ensure all your shareholders are aligned on any exit strategy. Also, when did you last update your terms of business? Do they properly reflect how you sell your goods and your services today? And will COVID-19 and the post-lockdown period change how your business operates in the future? Do you want to change your payment terms? If your business is online, do you want to change your delivery terms? Will the type of customers or suppliers you're working with change? It's always wise and to be encouraged to review your T's and C's regularly to see if any updates are needed and if changes to your business operation have been made or will need to be taken post-lockdown. And if so, your terms and conditions accurately reflect this. It's also a good time to look at your key customer and supplier contracts. Harriet has talked about the importance of the Force Majeure clause, so check that you have such a clause included, and also check generally that the contracts are up to date, delivery and payment terms are being adhered to, and any service level agreements included in your contracts are still appropriate and relevant. In particular, check that the documents and the contracts are still current, and if any are due for renewal soon, start discussions early. Whether it's to renew on the same terms, whether you want to negotiate some different terms, or maybe you may want to terminate the contract. When things pick up, you don't want to find that your key customers or suppliers are no longer contractually bound to you and have agreed better terms with a competitor. Think also about data protection. Whether you're already geared up for remote working or you had to hurriedly supply laptops and other equipment to your staff for them to work from home, your business will still have personal data that it's responsible for, irrespective of where that data is accessed. Do you need to reassess data protection protocols for your staff or provide them with additional training? Are there any changes that need to be made to your privacy policy or your internal privacy rules? And if working from home has been a great success for your business, you may want to consider your employee policies and working from home practices if working from home may continue to increase in the future. It may be indeed that you need less space to operate your business in the future, so do check your leases or licenses for any break clauses or amendment provisions to see if you can make changes to them. Statutory books, I don't want to go into too much detail, but it's again a good opportunity to make sure your statutory books are up to date, for example, with any shareholder changes, and your records at Companies House reflect the current standing of your business. Do check the PSC register is correct, and the director records reflect the current position of the business. This is a really good chance to ensure all statutory and government bodies and authorities are aware of any changes made to your business. some of which may be as a result of reacting to the current crisis. The number of times we undertake advice for people wishing to sell their business and their stat books are out of date and need to be reconstituted, which is not only time consuming, it can be embarrassing when looked at by potential buyers. So it's a really good opportunity to look at this. To also make sure you've taken advantage of, or at least have considered, all the government schemes that are available that are intended to alleviate pressure on businesses at the current time. This is not the time or the webinar to go through all of these in detail, but ensure you have considered the furlough schemes, tax deferment options, various banking and financing schemes that are on offer, account filing extensions, etc. They are all there to help and to make sure, so do make sure you have considered whether they are relevant for your business and do take relevant advice as required. And finally, I think it's a really good chance to see how your particular sector and to analyse how your particular sector has been affected by COVID-19 and consider whether you need to diversify or de-risk your business or focus in particular on one part of the business to make the most of the opportunity that lockdown presents. If your business remains strong, there could be opportunities to consolidate in your sector or diversify indeed by acquiring a business through an accelerated M&A or a purchase from administration or pre-pack. The price you pay should be considerably less than if the business is fully functioning and operational, but there are considerable risks also, so it's not for the unwary. Again, this is a topic for another day, but all I would say is if you are considering some sort of purchase out of administration or some accelerated M&A process, make sure you get specialist advice early in the process. So that's a very quick canter through some of the areas of your business you could consider reviewing if as by one happy byproduct of this crisis, you have a little more time on your hands. Each business is different, we know that, and what you focus on now could ensure you're in a good position when things become whatever the new normal looks like. No one has been through this before, we're all learning as we go, but just make sure you are as far ahead of the game as you can be in your particular sector when we get out of this current crisis. Right, I'm now going to hand over to Ben to talk us through some of the insurance implications.
Thanks, Adam. Much appreciated. Good afternoon, guys. Obviously, as per the slide, I'm the director of Macbeth Insurance Brokers. I'm going to use the next 15 to 20 minutes to discuss where we see increased risk and exposure both now, in the short to medium term, and finally longer term. I'll also provide an update as to how our industry is dealing with the pandemic, and lastly a summary including things to consider moving forward. Now, you'll probably have no surprise when you see the next slide. The first item on my agenda is business interruption insurance. Obviously very topical both in our industry but also the business community as a whole at the moment. In its most basic format, the cover is designed to protect any lost profit and or income depending on how your policy is set up. Now, traditional BI cover is subject to two main key trigger points as per that list. So we've got the material damage proviso, and it has to be specific to your premises. So in layman terms, there has to be physical damage at your own property for any cover to actually attach to the main policy. Now, most BI policies provide additional extensions in cover. They generally have sublimits, so they won't go up to the same sum insured as per the main primary level, but they'll be sublimited anything from generally 10,000 to 100,000. Now, the key extensions that I want to focus on, where I think there potentially could be some cover during this crisis, is firstly the non-damage denial of access section. It pretty much does what it says on the tin. Firstly, it denies you access to your premises, and secondly, there doesn't have to be any signs of actual physical damage. The problem is that cover is generally subject to an incident or occurrence happening within a certain distance of your main premises, which is generally no more than a mile, and it has to be imposed by a competent authority. The second extension, which has caused probably the most controversy in our industry at the moment, is the public authority extension or closure by public authority. This is basically your inability to use your premises due to restrictions imposed by a public authority during the period of insurance following an infectious and or notifiable disease. The big point here is the definition of, or the lack of definition in terms of infectious and or notifiable disease. Some policies define and list what they class within that definition. If that's the case, then obviously no cover will attach to the policy. because when the policy was first issued, COVID-19 didn't exist. Where there are potential question marks are the policies that don't define a notifiable disease. So they're completely silent on that fact. And that's where the insurers that don't list it are having problems. The biggest issue, so let's say, for instance, you've got the closure by public authority extension and the notifiable disease isn't defined in the policy wording. You've got two ticks, so your policy theoretically has been triggered. The biggest problem, I think, next is going to be actually quantifying the loss. Every BI policy has a business trend clause, which basically assures that the policy isn't picking up the general downturn in the economy. That's something that's just not insurable. If we use a restaurant as an example, obviously the restaurant has been shut by the public authority. The government have closed down all businesses, especially in the hospitality sector. However, the interruption to their business is not necessarily solely due to the closure of their own premises, but also the wider economic downturn. And I think that's going to be the main key, trying to actually quantify what the true loss is. If we then skip over to business equipment, now this again seems very obvious, but don't leave yourself underinsured is the key message. When the lockdown first went into place, business owners' main priority was to make sure their staff were up and running and could work remotely. What they weren't necessarily thinking about was to ring up their insurance broker and tell them they bought lots of new kit. Now, not only could the item you forgot to declare not be covered, but you could also be penalised for underinsurance in general, which in turn could mean insurers applying average to any claim settlement. So again, as an example, let's say, for instance, you have a claim of £10,000. It turns out that you're actually 20% underinsured. You'd only get a settlement from the insurer of £8,000. So you'd only get the 80% because they deduct the 20% where you're underinsured. So you just need to take those sort of things into account. Some policies do provide additional extensions in cover, and these extensions will be found generally under the normal material damage section of the policy, or what we would call the general office content section. Within there could be something called, well, different insurers use different terminology, but generally it's items temporarily moved elsewhere or to a third-party location. If you have that extension, there's a very good chance it'll be sublimited, but at least you'll have some cover whilst the business equipment is stored at a member of staff's own property. However, the most simplest form of doing this and the safest is to probably add an all risk section of cover, which will automatically provide cover for property that you keep away from the premises. Okay, so that's probably the best and safest option. Again, it seems very obvious, but these are things that I know as an insurance broker that clients haven't informed us of. I've put motor fleet on here as well. Now, this is slightly different because actually on the motor fleet side, it's actually a reduced risk. So again, I've put benefit. Make sure you are speaking to your broker and try and benefit in terms of a premium saving. If you've got a large motor fleet and half of those vehicles aren't being used, then if you saw the vehicles and then speak to your insurer, there's a chance that you can reduce the cover to what we call laid up fire and theft only. Now, by doing that, it removes any road risk cover, which is the more expensive part, but it still means if the vehicle is stolen or if there's an arson attack on the vehicle, at least you have cover for those scenarios. You get a very good premium save with doing it, so it's something we would recommend. If you don't go as far as necessarily sawing your vehicles, again, most vehicles are going to be doing a lot less miles. So if initially you've declared to your insurer you're doing quite large mileage, then speak to them and see by reducing the mileage, can you get a premium saving? The key message with all of this is obviously keeping your insurer or your broker up to date. I've seen a lot of clients that, because of the current crisis, have been using vehicles for other things that aren't necessarily related to their own business activities, such as voluntary work or courier services. If you're doing that, again, just make sure you're speaking to your broker. A lot of insurers are being very flexible, but better to be safe than sorry. Looking at the more short to medium term risks, so I've just mentioned what we see as the sort of the immediate impact of businesses. Short to medium term, first thing I've got on here is property. Okay, whether you're a landlord or tenant, you have responsibilities surrounding keeping property safe and secure whilst empty. Nearly all policies will naturally have some form of unoccupancy condition, which generally kicks in after a 30-day period. Now, after that 30-day period, it will be subject to you doing weekly inspections. It would also be potentially sealing up letterboxes, switching off utilities, etc. So there's various things as a landlord or a tenant you have to make sure you are doing to comply with that unoccupancy condition. Some insurers, in addition, will also actually reduce cover down to flea only. which is fire, lightning, explosion, and aircraft. So they actually reduce the perils. They don't give you any premium reduction for doing this, but obviously you do have less cover. So it's something you just need to be wary of. Make sure you're requesting flexibility. Insurers are very aware that a lot of properties are sat there empty. And we've seen throughout the industry that many insurers are increasing that 30-day period to either 60 or 90 days. So make sure you are speaking to your broker. Statutory inspections. Now, some properties will have various items of plant that need statutory inspections carried out either every 6 months or annually. Now, these could be industrial boilers, lifts, those types of pieces of plant. Due to the difficulty in actually accessing those premises and also actually getting an engineer to attend site, again, I'd recommend that you speak to the insurer, just explain the circumstances. In most cases, insurers are being very flexible where they can be. Don't rely on loss of rent. Again, this is very similar to business interruption under a commercial combined or business policy, in the case that in order for cover to be triggered, there has to be form of a material damage claim. Okay, so don't rely on the normal loss of rent cover to kick in. There are also extensions in cover, very similar to a commercial policy, and a lot of them will mention infectious disease, but again, check the definition. The majority of property policies that I'm seeing list down what they include within that definition, and therefore, again, there'd be no cover. Also remember that the loss of rent section under a building or property owner's policy is not a rent guarantee policy. Now, under a rent guarantee, there potentially could be some cover, but generally speaking, it will be subject to you taking measures to remove the tenant, which in the current climate probably isn't going to happen. Moving across to cyber and crime. They are different cover heads, they are different types of form of insurance, but they have certain similarities. And both, I believe, have increased exposure due to less control whilst working at home. We'd always recommend providing staff with company-owned machines rather than individuals using their own devices, as this creates a bigger risk and lack of control around things such as antivirus software, general software updates, secured VPN and hosted services, and lack of network control. And another big thing that cyber insurers are very wary of are individuals saving personal data on their home devices. Now, not only would these things cause greater risk to the business, but could also mean you're in breach of a security warranty under the policy. So again, it's very important that you check, and 99% of these policies will have some form of security warranty, not all, but most of them will. Moving to the crime section, naturally the communication isn't going to be as fluid when working from home, and therefore you have to be more alert to fraudsters. Social engineered crime is a huge risk in the current climate. We're seeing more phishing scams and push payment fraud than ever before. People are also very busy and under intense pressure, which again, unfortunately, fraudsters will take advantage of. Not necessarily a nice thing to think about, but internal fraud and staff. It still remains one of the biggest threats to businesses. Staff may become disgruntled with the business, potentially, depending on furlough arrangements or redundancies, as well as suffering financially themselves, so you have to stay alert as a business owner. Simple things such as dual payment controls are key, as well as not having just one person responsible for reviewing the bank accounts. Moving to those longer term liabilities. Employer's liability. Naturally, as an employer, we have a duty to keep our staff safe. There are two main potential exposures I see here. The first, a business is not providing appropriate health and safety measures or following government advice. As a result of that, a member of staff falls ill or worst case scenario dies. Secondly, working from home. It can cause both physical but also mental stress and pressures. How many businesses do you actually know that have carried out a workstation assessment, for example? Probably not that many. Directors and officers. IBB did a webinar a couple of weeks back. During that webinar, they mentioned the various duties and responsibilities that directors have. If those duties and responsibilities are breached, then potentially it could bring about a claim against their own personal liabilities. The most obvious threats in the current climate I see would be wrongful trading and or some form of insolvency. So again, they're the sort of things we could see coming in future months or potentially years. Employment practice liability. It's connected to the directors and officers, and generally speaking is brought in conjunction under what we call management liability policy. We're expecting to see a large number of redundancies. Initially, I was going to say later in the year, but following the announcement earlier today that the furlough scheme is now being pushed back to October, I'm expecting maybe that won't happen till the beginning of next year, but either way, I think there will be a large number of redundancies at some stage. When that happens, there's a very good chance that that will increase employment actions due to either unfair dismissal, discrimination, those type of events. The industry as a whole and business interruption. Now, like I mentioned earlier, I'll be completely honest, the majority of policies are not going to provide any cover. And the main reason being the fact that the key trigger point of property damage isn't going to be affected. And secondly, the majority of policies have a clear definition of what they class as infectious or notifiable disease. Those policies that do offer the extensions and don't define what an infectious disease is should be paying claims. You've probably seen that several class action groups have been set up recently by disgruntled policyholders. This involves insurers such as Allianz, Hiscox, Russo Alliance and QBE. The biggest concern that I have surrounding those class actions is the cost and the length of time it's actually going to take to get any sort of final decision. And it's whether those businesses are still actually trading by the time they actually get that final decision. In terms of what we're doing as a business, our head of claims provided me with some stats this morning. To date, we've reported 48 BI claims, of which only 2 have been accepted, with quantum to still be agreed. The majority have been declined for spurious reasons, and with insurers trying to rely on the intention of what the policy was supposed to do rather than what it actually states in black and white. That's one of my biggest grimes. We're challenging any repudiation and then helping our clients to follow insurers' complaints procedures. We've also implemented a free legal review service via our business network, who will review each case on its own merit and then provide a legal opinion as to the strength of any further challenge. In addition, we're helping clients pursue their valid claims with the Financial Ombudsman Service. Now, just remember, in order to utilise that service, there is some qualifying criteria. That criteria is that a micro enterprise or small business that employs fewer than 50 people and whose annual turnover is less than £6.5 million. There's also a limitation as to the size of the award that the FOS can grant, which is no more than £355,000. Now, that increased quite substantially compared to last year. And in the majority of claims for SMEs, that's probably going to be enough. In terms of all other claims, it's slightly more positive. The industry seems to be responding to those claims in a much better fashion. In terms of us, the majority of business travel and event cancellation claims we've seen have been paid, so that's good news. Again, insurers are trying to be flexible where they can. And the key message is don't be afraid to ask the question. Your broker should be trying to be as proactive as possible. If you're making general material damage changes, such as reducing stock levels, selling vehicles, for instance, then those changes are very easy. And for doing so, you should be returning a refunding premium. Remember, like I mentioned earlier, a lot of policies will have various conditions or warranties surrounding security and an occupancy. Again, speak to your broker. In most cases, insurers are going to offer some flexibility. The big thing that insurers seem to be pushing back on, we've had some acceptance, but not from all, is trying to reduce turnover and wage roll estimates mid-term. Generally speaking, for liability insurance, you estimate a figure at the beginning of the year and then you declare your actual numbers at the end of the year. Now, obviously, those estimates are changing dramatically throughout the next 12 months. Some insurers have allowed clients to reduce those levels mid-term, and for doing so, have obviously reduced premiums. But some insurers are not willing to budge on that. But again, ask the question. A lot of insurers are also allowing pro rata cancellations, even if you are on what we call a minimum deposit premium policy. So again, if you are really struggling, you need to cancel the policy, then insurers generally are trying to help where they can. In terms of what our regulator is doing, so good news, the FCA announced on the 1st of May they are seeking legal clarity on business interruption insurance to resolve doubt for businesses who are facing uncertainty with their claims. Now, I'm going to read you out a statement from Christopher Woolard, who is the interim chief exec of the FCA. So he said, "We have been clear that we believe in the majority of cases, business interruption insurance was not purchased to and is unlikely to cover the current emergency. However, there remain a number of policies where it is clear that the firm has an obligation to pay out on a policy. For these policies, it is important that claims are assessed and settled quickly. Our intended court action is designed to resolve a selected number of key issues causing uncertainty as promptly as possible and to provide greater clarity for all parties, both insured and insurers. It is clear that decisive action is appropriate given the severity of the potential consequences for customers. Now, that's certainly a move in the right direction, I think. The FCA have wrote to a number of insurers, predominantly those insurers that have policies that aren't defining what a notifiable disease is. And they are awaiting response. They've asked for a response by the 15th of May. So we should hear, hopefully by the end of the week or beginning of next week, as to sort of the next process that the FCA are going to take there. But it's certainly a move in the right direction. The FCA are also looking to implement a package of measures designed to help both consumers and small businesses surrounding flexibility in terms of both cover, but also payment of premiums. So a lot of insurers, again, trying to help with payment holidays where they can. And like I mentioned earlier, with regards to that flexibility piece, the FCA are trying to get insurers to offer more and put more on the table to help clients. So in summary, things that you should be doing moving forward. Key message: review and understand your own policy coverage. Speak to your broker, very important. Understand and comply with any policy condition or warranty. Ensure any claims reported within the notification period. Again, if you're unsure whether cover is going to actually exist and be triggered by a policy, you should still notify, because what we don't want to happen is you don't notify, you then wait and find out what the courts are doing. The insurer could potentially kick out your claim because you haven't notified within a certain period. So again, that's quite important. Follow the correct procedure when claiming and or complaining. And finally, understand your rights and what the Financial Ombudsman Service qualifying criteria is. Thank you very much for listening. I'd also like to thank IBB for inviting us along to the webinar this afternoon, and also the Chamber for hosting it. So yeah, thank you very much.
Thank you so much, Harriet, Adam and Ben. I'll just start my video so that people can see where the voice is coming from. Those of you that joined late, I'm David from Thames Valley Chamber of Commerce. Thank you so much for such a rigorous approach to force majeure, and I think I've been pronouncing it wrong all along. So I found the information really rich. So thank you. We do have a couple of questions. Perhaps the first one to Ben. My business interruption claim has been declined. What are my options?
Thanks, David. Okay, as I alluded to earlier, there are options. Firstly, the most important is following the insurer's correct procedure. So initially, if you get a repudiation, how we are dealing with this is we would then challenge that first repudiation. We get another response back from the insurer. You then have to make sure you follow the insurer's complaints procedure. So follow the complaints procedure. If the claim still gets kicked out, depending on the size of the business, if they are under that 6.5 million turnover threshold, we then recommend they report that straight to the FOS, or the Financial Ombudsman Service, to take it further. If they fall outside of the 6.5 million, then they're quite entitled, and we will try and help them get their own legal opinion and challenge the insurers that way. But there are options. Okay, that's clear. Ben, can I ask you another one? Will insurers reduce cover midterm in order to show a premium saving? Well, yes, they will, assuming the question relates to turnover and wage roll reductions. Then again, not all insurers are going to do that. They don't necessarily have to do that. But again, we are hoping, with the FCA's help and the FCA bringing in those additional pack of measures, that they will force insurers to go down that route. We've been successful doing that on a number of occasions, where certain business sectors, their turnover is falling off the cliff, obviously. And as a result, we've got insurers to agree to reduce premiums midterm. So yes, it can be done, but it's a conversation you should be having with your broker. I see, okay. Excellent. Harriet, one for you. I have a force majeure clause that mentions an act of God. Is coronavirus an act of God?
Gosh, that's a good question, and one really that depends on the rest of the clause and how it's the act of God is used in the clause. Sometimes it's definitely it will be part of a including but not limited to phrase that says act of God.
Mm-hmm.
But I think generally the thought around act of God has been that it covers natural disasters, things like floods and earthquakes. which clearly have an impact on the ability to fulfil any obligations under the agreement. But I mean, particularly how it's affected the UK, I would say that the COVID-19 itself probably hasn't prevented lots of contracts to be performed, but probably actually the government lockdown. So it's an interesting one that you probably worth further investigation, and I'd be happy to help anybody look at it further.
Okay, fantastic. And one for you, Adam. You mentioned statutory books. Everything is filed at Companies House. Do I need anything else?
If everything's filed at Companies House, that's a good start, but a lot of businesses are under the misapprehension that's all they need to do. Now, even though now a lot of companies are incorporated online, there is still a requirement under the Companies Act, for certain key information to be kept with the company, and if it's not kept at the registered office of the company, then you need to let Companies House know. And that sort of key information revolves around directors, the directors, secretaries and shareholders, security and loans, and results of shareholders' resolutions. So the honest answer is people may remember some time ago you used to have folders which had the statutory books, and there is an obligation still to keep a lot of that information at the company. So it's not just a case of keeping it at Companies House. It does have to be kept at the company as well. As I said earlier, we do come across situations when we're acting on disposal processes and a due diligence question comes up around that. The statutory books are provided and they are out of date, and then they need to be reconstituted, and that can be quite time intensive and needs to go back quite a long way. So do make sure your company books are both online at Companies House and also within your registered office or as part of the business are kept up to date and online. Okay,
excellent. Thank you so much. I believe that we've come to the end of our webinar. Are there any further comments or additions that our panelists would like to make before we close? Okay, well, that's fantastic. Thank you all for joining us. Harriet, Adam and Ben, thank you so much. I hope to do more webinars with you. It's been a real pleasure. And
thank you.
Thank you everyone for joining us.
Thank you.
And we look forward to doing this again soon. Thank you very much.
Thanks.
Thanks.
Thank you.